Thank you for listening to the Council of Institutional Investors' Voice of Corporate Governance, the #1 corporate governance podcast in the U.S. as determined by Million Podcasts. I'm your host, Jeff Mahoney, General Counsel of CII. The purpose of these monthly episodes is to update CII members and the general public on significant developments in corporate governance and capital markets regulation and CII's related advocacy activities. This update covers a period from March 3rd to March 26, 2026. The following is my top 10 list of events over that period. Number 10, on March 3rd, an individual whose retirement savings were invested in Cushman & Wakefield's 401k plan filed suit against the commercial real estate firm, claiming it mismanaged the retirement plan by selecting an underperforming fund that exposed investors to climate-related risks. The lawsuit filed by 401k participant Renee Tisvek said Cushman & Wakefield violated the Employee Retirement Income Security Act of 1974 when it invested in the Westwood Fund. The lawsuit alleges that the Westwood Fund exposed employee retirement savings to significant, unreasonable climate-related financial risk, apparently failing to employ any climate risk management strategy at all. Furthermore, the lawsuit says the fund boasts an unsavory combination of financial underperformance and unreasonably high fees, while at the same time exposing investors to massive amounts of climate-related financial risk that threaten to wipe out years of savings under any number of highly plausible scenarios. Tisvek is asking for a ruling that requires at least 4 actions. 1. Each fiduciary found to have breached their duties to pay back the plan's losses resulting from the breaches. 2. The appointment of a special master to oversee the development and implementation of a revised investment policy for the plan. 3. The defendants to assess all investment options according to that new policy. And 4. Tisvek also seeks the removal of those fiduciaries found to have breached their duties, as well as interest, litigation costs, and attorney's fees. Michelle Yao of Cohen, Milstein, Sellers, and Toll, who is counsel for Tisvek, told Law 360 the suit is a first-of-its-kind legal challenge under ERISA that will hopefully show 401k plans that the financial risk associated with climate cannot be ignored. Back in September, Reed O'Connor, a judge in the Federal District Court for the Northern District of Texas, ruled that American Airlines pension plan fiduciaries violated ERISA's duty of loyalty provision, but also said the airline would not be ordered to pay a financial penalty because the plaintiff failed to sufficiently establish monetary losses to the plan were a result of that violation. Number 9. In a March 10th press release, ExxonMobil announced that ExxonMobil's board voted to recommend that the company move its incorporation from New Jersey to Texas. ExxonMobil pledges that the relocation will not affect shareholder rights. The release says the board determined that shareholder rights under Texas law are largely comparable to those under New Jersey law, and in some areas, stronger. Release adds ExxonMobil has no plans to adopt elective provisions under Texas law that would diminish shareholder rights currently in place. In May, the Texas legislature passed 2 laws significantly restricting shareholder rights. One law prohibits any shareholder of a nationally listed corporation that has opted into the law's provisions from submitting a proposal for consideration at a shareholder meeting unless the shareholder or group of shareholders meets 3 requirements. 1. Owns at least the lesser of $1 million of market value of voting shares or 3% of the corporation's voting shares. 2, owned and continues to own those shares for at least 6 months prior to and through the shareholders' meeting. And 3, solicits holders of at least 67% of the voting shares to vote on the proposal. The other new Texas law permits corporations to prohibit shareholders or groups of shareholders who beneficially own less than 3% of the corporate stock from bringing a derivative proceeding against publicly listed companies or at any other corporations with 500 or more shareholders. Number 8. On March 13th, Glass Lewis published an article raising alarms about 13 pieces of legislation that are being passed by state legislators to effectively create a chaotic, impractical patchwork of state regulation that makes providing objective proxy advice near impossible. A Texas bill passed last summer was enjoined by a Texas federal court. That law stipulated that if advisors provide advice based on ESG or DEI factors, social credit or sustainability scores, or membership in an organization that bases its assessment of a company's value on non-financial factors, the advisor must provide the following 4 items. 1, a statement that the service is not being provided solely in the financial interest of the company's shareholders because it is based wholly or partly on one or more non-financial factors. 2, brief explanation of the basis of the proxy advisor's advice and recommendation. 3, a copy of the report to the company that is the subject of the service. And 4, a statement on the advisor's website that its services include advice and recommendations that are not based solely on the financial interest of shareholders. Furthermore, proxy advisors would be required to provide similar disclosures to their clients, companies, and the Texas Attorney General whenever they offer different advice to different clients that have not expressly requested services for a non-financial purpose. Texas bill also mandates that proxy advisors decide and disclose which of the differing recommendations was in the financial interest of shareholders. Legislation would create a private right of action for companies and shareholders to challenge advisors for failure to comply with the rule. Despite the Texas federal court putting the brakes on the law, many states are considering similar legislation. In Indiana, a bill was introduced in January, passed the House in 2 weeks, quickly passed the Senate a few weeks later, and has already been signed into law by the state's governor to be effective July 1, 2026. Copycat bills are now pending in 9 other states that would require proxy advisors to perform written financial analyses before recommending against management, or force advisors to make misleading disclosures to their clients, companies, and the public. For example, if a proxy advisor recommends a vote against a director who did not attend 50% of meetings last year, the advisor would be required to include a lengthy prescribed analysis that discusses, among other things, the expected short-term and long-term financial benefits and costs to the company, or a written warning, which would also be provided to the company that the client is receiving proxy advice without a written financial analysis. This requirement would apply to every issue on any proxy ballot with an against recommendation. Several other states are advancing similar legislation, some geared toward advice to state pension plans and their asset managers, and some intended to apply to any company regulated by the state. Among other things, these bills would prohibit proxy advice on executive compensation that undermines the use of discretion by an independent compensation committee of the issuer's board of directors. In other words, shareholders may have a right to a say-on-pay vote, but it would be illegal for them to get advice to cast a vote against management. The Glass-Lewis article argues that these bills are unworkable, conflict with federal law, and blatantly seek to suppress proxy advice that takes any perspective different from management's. The article adds, the bills also create unnecessary costs for proxy advisors and their clients, none of whom have asked for these additional analyses or need to be warned about what type of analysis they are receiving, but who will nonetheless foot the bill for the blizzard of mandated paperwork. Number 7, March 19th, the Interfaith Center on Corporate Responsibility and As You Sow, represented by Democracy Forward, filed a lawsuit to block the U.S. Securities and Exchange Commission from continuing to implement its new policy of refraining from considering most no-action requests submitted by companies. The policy allows companies to omit shareholder proposals by filing a simple letter and receiving a no objection statement from the SEC without the benefit of any analysis by the Commission. The lawsuit, which was filed in the U.S. District Court for the District of Columbia, argues that the policy was implemented without the notice and comment rulemaking that is required by the Administrative Procedure Act when an agency adopts or effectively alters binding regulatory standards. The lawsuit says the SEC circumvented the procedural safeguards of the APA and effectively changed how Rule 14A-8 operates through informal staff practice rather than through rulemaking. The plaintiffs also argue the SEC's new approach will lead to the exclusion of shareholder proposals and weaken a core mechanism of shareholder participation in corporate governance. The plaintiffs also say the resulting harm to investor confidence in the transparency and accountability of the markets contradicts the SEC's statutory mission to protect investors, maintain fair and orderly markets, and facilitate capital formation. ICCR CEO Josh Zinner said the SEC's actions in undermining the shareholder proposal process are a short-sighted departure from the decades of precedent in which shareholder proposals, a critical tool in a private ordering process, have led to important improvements in corporate governance and corporate practices that benefit both companies and investors. The lawsuit asks the court to declare the SEC policy unlawful and permanently enjoin it. Number 6, on March 20th, a faith-based investor filed a lawsuit in the U.S. District Court for the District of Columbia against United Health Group, seeking to compel the healthcare company to include a shareholder proposal on its proxy ballot. The proposal asked the company's board to publish a report detailing the healthcare impact of its acquisition strategy over the last decade. The lead filer is the Sisters of the Holy Names of Jesus and Mary, a member of the Interfaith Center on Corporate Responsibility. The proposal raises investors' concerns that United Health Group's vertical integration creates risks for the healthcare system, which are amplified by the company's status as the nation's largest health insurer. Number 5, on March 19th, a bipartisan group of 18 U.S. Senate Committee on Banking, Housing, and Urban Affairs members sent a letter to U.S. Securities and Exchange Commission Chairman Paul Atkins. The letter urged the commission to examine Chinese companies' reliance on variable interest entities to be listed on U.S. exchanges, alleging that these opaque corporate structures may advance Chinese government objectives in ways that undermine investor protection in fair, orderly, and efficient markets. Specifically, the senators request the commission closely examine, among other topics, 2 items. 1, whether existing disclosure requirements sufficiently explain the legal and operational limitations and risks inherent in variable interest entity structures. And 2, whether additional commission tools or revised disclosure obligations are warranted to ensure that variable interest entity contractual claims cannot be easily frustrated under the People's Republic of China law. In addition, the signatories underscore the importance of continuing to evaluate the risk involving PRC-linked broker-dealers that serve U.S. retail investors, and stress that any policy response should protect investors while preserving their ability to make informed investment choices. Accordingly, the senators highlight several questions that merit attention, including whether enhanced disclosures, clarified supervisory expectations, or stress testing of cross-border data resilience frameworks could strengthen investor protection. Number 4, on the March 10th plenary session at the Council of Institutional Investors Spring Conference, Senator Elizabeth Warren of Massachusetts, the ranking member of the Committee on Banking, Housing, and Urban Affairs, told CII members that corruption in the current administration could break the U.S. financial system. Ranking member Warren gave a dozen examples of what she viewed as this corruption. Senator Warren said, quote, Trump's SEC has turned from a financial cop on the beat into a willing accomplice for insider favoritism, unquote. Senator Warren noted that under the prior SEC chair, the commission had filed 2,700 enforcement actions, but since the president had taken office, the SEC had filed only 300. Number 3, on the March 9th plenary session at the Council of Institutional Investors Spring Conference, U.S. Securities and Exchange Commission Chairman Paul Atkins was interviewed by Brian Mahoney, partner at Skadden, Arp, Slate, Marr, and Flom LLP and affiliates. During the interview, Chair Atkins stated that the SEC will evaluate its new hands-off approach to no-action decisions for shareholder proposals at the end of the 2026 proxy season and decide how to proceed from there. And in response to a question from Mahoney about how Chair Atkins was thinking about balancing between excess disclosure versus investor protection, Chair Atkins responded by stating, basically, our mantra now is to get back to basics. So I don't know what your house looks like, but my attic, garage, and basement all need a really good spring cleaning. At some point, you have to go through and have discipline and say, no, this is no longer fit for purpose, and we need to throw that out and move on. So I think that's kind of the problem right now with large disclosure. For example, The first thing that investors see when they open up the 10K is risk factors, like what keeps management up at night. The idea was a few pages of bullet points. Well, now it's not that at all, of course. The lawyers get to work on it, and oh gosh, you have to put all this stuff up front because where do you stop? And so under Jay Clayton, the commission said, well, if your risk factors section stretches more than 15 pages, then you need to put in an executive summary. So now you have an executive summary, you have risk factors, and then you have the balance of the 10K, which, of course, is embroidered with these risk factors because they supposedly are essential to the understanding of the company. So nowadays, there are a number of studies out that show that the risk factor section is the longest single section of the average 10K. We've diverted from the original intent of some disclosures. Things have expanded, and we have to balance it. We have to make sure that investors get the material information they need, and that's clearly defined by the Supreme Court from 1976 in TSC Industries versus Northway, that what is necessary, important for a reasonable investor to know whether to buy, sell, or hold, and that's been held through a number of other cases that are really key to the securities area. So it's an objective test. It's not, it'd be nice to know, it's an objective case because investors and shareholders are not monolithic. They have their own interest. And so we have to differentiate from that. Number 2, on March 9th, Council of Institutional Investors Spring Conference, CII members approved an amendment to an existing CII policy entitled Accountability to Shareholders that responds to recent instances when states reduce corporate governance standards in a manner detrimental to shareholder rights. The amendment specifies that when a jurisdiction meaningfully weakens protections for a company's shareholders, the board should conduct a review and disclose the specific standard that was weakened, an analysis of options to preserve protections, such as through private ordering, and the board's rationale for its decision. And my number 1 most significant development in U.S. corporate governance, capital markets regulation for the period from March 3rd to March 26, 2026, occurred on March 9th in connection with the Council of Institutional Investors Spring Conference, when Yumi Narita, Executive Director of Corporate Governance for the Office of New York City Comptroller, was elected to serve as board chair of CII. The other board officers for 2026 to 2027 are Margaret Madden, Senior Vice President, Corporate Secretary, and Chief Governance Counsel for Pfizer, co-chair; Jennifer Odell, Director of Corporate Affairs, Laborers International Union of North America, co-chair; Andrew Roth, CEO and Executive Director of the Colorado Public Employees Retirement Association, co-chair; Drew Hambly, Investment Director in Global Equity and Head of Stewardship for the California Public Employees Retirement System; and Dieter Weitenziger, Director of Investment Stewardship for the UAW Retiree Medical Benefits Trust, Secretary. That completes my monthly update on significant developments in corporate governance and capital markets regulation. If you have any questions regarding any of the issues discussed, please feel free to email me at Jeff, that's JEFF, at CII.org. Till next time, I'm Jeff Mahoney. Thanks again for listening to the Voice of Corporate Governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.